And we are live. Good afternoon, everyone, depending on where you're watching this live webinar from. Our apologies for coming behind schedule. Welcome to this live session. And in today's webinar, which is the first webinar we are having on this channel, we are talking about compulsory government acquisition, compensation, and your rights. What are your rights as a property owner in Nigeria when there is a compulsory government acquisition? What does the law say about compulsory government acquisition? What are the rights that you have when these things happen? These are what we will be talking about today in today's session. Welcome once again. I am Tosin Omotosho. I'm lead counsel at Charis Legal Practice, and our law firm, Charis Legal Practice, was awarded the Best Real Estate Law Firm in Nigeria 2025 by the African Excellence Awards. And our mandate is clear. We protect high net worth capital from avoidable legal risk. We are proactive and not reactive. All right, and we are diving straight right into the session for today. Now, as you would have seen around us, there's a lot going on in Nigeria. A lot of infrastructure is being developed, and this infrastructure needs real estate. The government are building new roads, railway tracks, hospitals, different infrastructure, and these are going to be what is going to be used for all this infrastructure. They will sit in real estate. All right. Now, so there is no spare land anywhere. There's no extra land anywhere. It's from the existing land that we have already that the government would convert into all this infrastructure to make our lives better. And how does this then happen? They take it from the existing owners. All right. So, and that is why there's a lot of compulsory land acquisition in Nigeria going on across the country because of infrastructure. So, how do you avoid this? How do you avoid buying land that has already been acquired by the government? Because that cheap land that you want to buy might have already been acquired. What's the process? What's the procedure? That's what we are diving into in today's live webinar. However, let's quickly do a short um, s- um, land law class. Okay, yes, I know we're not lawyers, but we need to understand what the law says about the land use in Nigeria. If you are an investor, individual investor, a real estate company, group of individuals, you need to understand. So now this is what the Land Use Act. Before the Land Use Act was enacted in 1978, lands were held all over the country in different modes. And what the Land Use Act did was to ensure that we had a unified system of land use, so that we had laws that were guiding how you could use land. And what's the law? A very critical creation that the Land Use Act created was a right of occupancy, and to vest land in a state in the governor, sorry. So all land in a state is held by the governor in trust for the people. He does not own the land in that sense, because if you own land, you cannot acquire what is already yours. So it is held in trust. It's similar to you're a parent, you have a nanny, and you're leaving for work. You tell the nanny this and this are for the children. When it's so and so time, give them their dinner, give them their lunch. Does it mean the lunch and the dinner is for the nanny? No, it's for the children, but the nanny is in charge of administering it. So we could say that is very similar to the position of the governor as regards all lands held in the state in different states in Nigeria. And when we talk about owning land, we actually mean that holding the ownership rights, holding the right of occupancy. And what the Land Use Act did was to create a right of occupancy in land. All right, it's very important that we state that. So now, if the governor can give you a right of occupancy, the governor can also take back the right of occupancy, and that's where revocation of a right of occupancy comes to play. So now, what does the law say? Does that mean that the governor can just take land from anybody? What does the law says? Now, sections 28 to 30 of the Land Use Act specifically provides for how this should be done. It says it must be for public purpose. So you can't take land for private purposes. It has to be for public purposes. And the requirement is that the formal notice of revocation has to be issued. The law is very clear. You see, there is no absolute power because when there's absolute power, it means that we don't have law and justice in the society again. And so, whilst in the Constitution, for instance, will say, "Oh, everybody has a right to life," but if someone commits an offense, that right to life can be taken and approved judicially. Okay, so the rights are not absolute. The rights are within limited boundaries. So this is what the law provides for that. If anybody is going to take your land, it has the notice has to be given and it has to be for public purpose. I remember this clearly. There's a case where a former president of this country had acquired some land and given to I think family members, but it wasn't for public purposes. All right. And after his demise, the the original owner of the land had gone to court successfully and won and got the land back because it wasn't for public purpose. All right. Like we would also see here, we have on the slide here an exact the exact verbatim of what the Land Use Act says that the revocation will be signed under the hands of a public officer who is duly authorized in that behalf by the governor, and notice must be given. Okay, so your land cannot be taken, and this procedure is not followed. That would be illegal. All right. Now let us now look at the land that we're talking about. We have different forms of acquisitions, and we have these three terms that I want us to take note of. So first we have committed. So we have land that is already committed, meaning it is acquired and is already slated for specific projects. These are lands that you should not buy at all. You don't buy land that is already committed because when we check, when we do the necessary checks, we would find out that it's been committed: a barracks, an hospital, a rail, an airport, a road. Now, another thing that I see happen often and that people fall into this trap is that people say, "Oh, they said the land is committed." But I've heard that since I was young. Now I even have children, and up till now, the government hasn't come to develop it. I heard that the land is committed, is to be a road is to be built there, or a railway is to be built there, or an airport is to be built there, or an housing estate is to be built there. But that has been like 20, 30 years ago. Now, the truth is, if it is committed, it doesn't matter how long it takes. The government might come, and do you really want to risk now losing your entire capital? I have seen real life scenarios that happen even to my family. When they wanted to acquire buy land, then said, "Oh, there's a ring road around this area. It has been in on the plan for a very long time." And so we had that in mind when we were buying the property. And many people did not bother and felt, "Oh, the government has been saying that since that they will do a ring road around this area." And you know the sad story. Many people built right in the middle of that road where was already a marked. And when it was time for the government to then start that project and build that road, the houses were taken off, full whole houses. Very sad story. So please, committed no is a no-no. You see, that is why we have it in red. Now we have land that is acquired but not committed for a specific purpose yet. All right. Now this is risky. It's risky. So let me also, before I go to the yellow, let me say something else about this red committed land. You can't perfect your title because you cannot perfect title on a property that is actually not yours. That the government cannot give you perfection of title over. So that's another reason why it's very risky. So now global acquisition, that's the yellow. That's okay. This land is acquired, but there isn't a specific purpose attached to it. Yes, it's just global acquisition. All right. So that the status is that it is risky. It's very risky, and oftentimes you might be able to ratify, but it will usually be expensive. So you want to weigh your options very well. Now we now have land that is free, is not been acquired. Okay, that is safe to buy. We have land that is excised, and if you've heard this term excision, gazette, I will be explaining that shortly. Now, in certain instances, when land government has acquired land for a particular purpose from the original landowners, the customary landowners usually, the family can go back or the community can go back and say, "Okay, we acquired 500 hectares of land, and can you give us back some of it. So maybe they, because the government will usually acquire in large quantities. So can you give us back? And then the government would excise it back to them. So the excision is releasing it back to the community, but it has to be gazetted. So if you hear excision in title, you want to buy a property and you say, oh, it's excision in title. The thing is, excision in title is very risky. They could be giving it back, they could not be. The government might give it back, the government might not give it back. Now, here is the risk, and let me demonstrate that. If you have you have this land was acquired by the government. You want to buy from this portion, and they tell you there's excision in progress. How are you sure that the part that will be given to you is part of what you want to buy? How are you even sure of the quantity of land that the government is going to give back? So that's why excision in progress is risky. If you're buying land that has excision on it, you want to be sure that that excision has already been gazetted. It's already been spelled out clearly that the government has released it back, not that it is in progress, to save your capital, Yes, so I hope that helps. Now, in situations where land is acquired, there should be paid compensation. That is what Section 29 of the Land Use Act provides for. So you're entitled to compensation. It has to be for, remember, the requirements that the law says. Notice has to be given. All right, it has to be for public purposes, and compensation has to be paid for. All right, now let's look at a few things that as a few quotes from the court. Okay, not quotes now. These are a few ratio decision, but I really don't want to get into all the legal stuff. So what does the court says? It's a sine qua non for a valid compulsory acquisition of land that there must be evidence of prompt payment of compensation to the owners of the land by the acquiring authority. All right, so that's a case decided by the court. And if you'd also look at the second case, that's Olateju and Commissioner for Lands and Housing in Kwara State. It says government cannot acquire land from an individual or community without the payment of adequate compensation. All right, so that's very important. We can see that this is what the law says. This is your rights. This is your rights as a landowner. So if you, please let me also state that if you purchase land and it is after your purchase that the government acquires the land, that is when you're entitled to compensation. But if before you purchase the land, the government had not acquired your land, the government had acquired before you buy it, meaning when you buy already acquired land, you can't get compensation. In fact, you bought nothing. And this legal maxim explains because you cannot give what you do not have. I can't sell to you what the government has already acquired. I should go and get compensation from the government if at the time when I bought it, it wasn't acquired. So that's why it's very important that part of the things to check when you want to buy real estate is to check that, not just do a search, but you want to check that using the coordinates, you want to chart and be sure that the land is free. Okay, and typically we have a 5-step due diligence framework that every property that our clients buy and engage for due diligence that we pass through. And stage 4 is called regulatory compliance, which is we want to check. So we engage a surveyor to check, is this land free? Is it committed? Is it under acquisition? It's very important because you don't want to risk your entire capital. We've had, unfortunately, sad stories of somebody who had bought land and then engaged us and said, "Oh, I really want to check, and is this land free from acquisition?" And then by the time we did, it was already gazetted. It was it was committed a military barrack. So it hasn't been built up till now. But like I said, the government can always come and implement whatever they have planned earlier. And so that's why it's important that before you buy real estate, make sure that you check. Don't gamble with your capital. A simple search is not enough. As you will see, we have other videos on our YouTube channel where we talk about details of due diligence. Beyond just a simple search, even beyond just the chatting, there's a lot that goes into due diligence to protect your capital when you are buying real estate. All right. Now, if you would like to work with us, if you have a question, that you would like to speak to a lawyer about, you can book a strategic legal advisory session. If you also need any of our services, you can go ahead and use the link in the description and book a strategic legal advisory session. At the session, we will be able to look at all the facts of the case, of listen to you and get all the necessary details from you and tell you whether to proceed or not with what you want to do. All right. So if you have questions, feel free to drop them in the comment section as we round up this session. Any questions as we round up? And for those who will be catching the replay, you can drop your questions in the comment section under this video and we will be glad to answer your questions. All right, thank you for joining in this live session and do enjoy the rest of your day.